Chirag asked the question. I answered it earlier this morning, and I'll just kind of reiterate my answers. The initial half of the question related more to visitor visa technicalities around having applied for a visitor visa in the past, coming on shore, you've got a pending offshore partner visa, and you apply for another visitor visa because you're waiting for the offshore partner visa to be decided. And I just had to kind of narrow the scope of the advice or the support that we can provide to visa users and this group. Visa and this group isn't intended to talk about visitor visa pathways per se. Obviously though, I'm very well aware that a visitor visa is often part of the whole pathway or the whole journey for couples, in that either they're applying for a visitor visa first to try to come here and apply for a partner visa, or they've done it the other way around like Chirag has, where he's already applied for a offshore partner visa, has actually already applied for a visitor visa and then looking to come in on that visitor visa, but understands that if they do that, if they come in on the visitor visa, that has an expiry date, that has a time restraint, and the offshore partner visa may take longer than the time given to them or his partner on the visitor visa. And the question was, can you apply for another visitor visa? The answer is yes, you can. But in terms of if that second application is refused, the effect of that refusal on the initial visitor visa application, that's something I would need to look into, Chirag, in order to be able to answer confidently, given that we've never had that scenario. I've never had a case where we've had an application submitted for a second visitor visa where there's already been a visitor visa granted, and that second visitor visa has been refused. So thankfully I've never been in that scenario, so I can't advise from personal experience, but also just to refine the scope, I can't provide extensive advice on visitor visa pathways to Australia in this group, unfortunately. As for evidence, for me and my wife will open up a joint account soon and sign lease. Apart from that, there's no other documents that will be in my name here. All my other necessary things and items are in my parents' name. So, Chirag, I suppose my response, specific to your scenario, because I know your case, because we've spoken about your case at length in different calls, having an Australian joint account, having proof of your Australian cohabitation, really are the two fundamental pieces of what I would call your Australian top-up evidence. You already have an extensive range of overseas-based relationship evidence, and you're just trying to kind of supplement, add to that, your Australian-based cohabitation and financial pooling evidence. So I think just having proof of your cohabitation here and proof of your financial pooling here, plus everything else you already have, is more than enough. I think you're definitely going to have enough on paper in order to meet the requirements. Again, based on what I know about your case specifically. In terms of police checks for Australian citizens in India, you've mentioned you haven't received a request, but that the website clearly states that Indian police clearances can only be issued to Indian nationals and not foreigners, so I'm unable to get Indian police clearance. If that is the case, then logically there's no need for you to apply for one. The department will apply the same policy to what you've read on their website. So I don't expect, therefore, for you to receive a request for an Indian clearance if that's the case. So if that is the case, leave that aside. If you receive a request, then that might be something we need to work through. It might be something that you need to revert back to the department if that request comes through. But if it's confirmed in writing in the department side that it's not required and you haven't received a request for one yet, then we have to assume you won't and just leave it at that. Can you harass immigration by submitting an inquiry like 4 times a month? You can. My answer in writing to you there, Chirag, was you can. There's no limit, of course, in terms of how many online inquiry forms you submit. But I suppose I approach this question as a human and understanding that ultimately you're dealing with other humans at the other end of that inquiry form submission, and humans that have a lot of authority and discretion in terms of who they assess, how they assess them, how quickly, what they prioritize, who they don't prioritize. So we here never spam offshore consulates when it comes to pending offshore applications. We will offer to communicate with offshore consulates for clients and try to seek updates periodically, but we won't, as you've put it, try to spam them, because the last thing I need or that we want is for us to in some way be blacklisted or ignored because we're that type of firm that constantly spams them for updates when we know that they don't provide updates. That's the starting point. It doesn't realistically matter how many times you contact them or call them. 99% of the time, you're not going to get any type of detailed update. That's the reality of dealing with offshore consulates or just the Australian government in general. You are a number in a sea of applications, and they don't give specific advice or updates or timeframes in terms of how long individual applications will take. And often the person you maybe speak to or get through to is not the person that's making the decision. So they're just kind of your top of funnel, top of level customer service representative, and they'll just give you a generic response, if anything. So keep that in mind. But to your question, of course you can harass them as much as you like, but approach it logically. And I would say, look, one a month probably is sufficient to get your point across that you're still waiting. And anything more than that, I think, becomes potentially annoying to offshore consulate assessors, and you don't want to get on their bad side because there's no transparency. You just don't know what effect that has on your application by constantly trying to contact them. But of course, you may have a different experience. You may read about different experiences where people have contacted the consulate for their own applications, and the next day their applications are submitted. We see that all the time, hear about that all the time, anecdotally in the industry. So it just shows you the uncertainty or the discretion that they have. So you just have to approach it carefully. In terms of your last question, can you convert a 309 to an 801? Do I need to apply again for the 801? So no, you don't convert a 309 to an 801. When you submitted the 309, or when you submit a 309, you're actually already submitting for two applications. You are submitting for the 309 and for the 100. It's the double lodgement. When the time comes though, depending how long that application takes and depending how long you were together for prior to lodgement, it's likely they'll only grant the temporary visa first, which will be the 309. And then 2 years from when you made that combined application, the applicant becomes eligible for the 100, which is the permanent half of that double application. When that door opens, so about 24 months from lodgement, but a month prior, so let's say 23 months from lodgement, you'll get an email. Assuming the 309's been granted. Prior to that, you'll get an email from them saying, hey, you're now approaching your 24-month mark. This applicant is now eligible for the assessment of their second stage process. Please prove you're still together. Attach some updated documentation, submit the permanent stage application form through the IMI portal. So you submit the form, you attach your relationship evidence, your updated evidence dated after the approval of the temporary visa, and you attach everything, and then after the 24-month mark ticks over, eventually they'll assess that lot of information to prove that to see if you're still together, to see if the applicant's still eligible for the permanent. Thankfully, there's no additional fee. You don't pay the government another fee to be assessed. That's all part of the combined application fee you submitted initially. Okay, so it's not that you're converting necessarily the 309 to the 100. You have technically already submitted that. It's just that they will grant the permanent over the top at some point, generally 24 months from lodgement of the initial combined application.